This matter comes before the court at this time for further proceedings. Ms. Goheen, give me your assessment of the status of this case.
Judge, we are in the position where we obviously don't have an agreement as to shared residency in this case. And so this is our motion to modify the temporary order. And we're requesting shared residency for my client. And we're also requesting a restraining order for mom, preventing her from exchanging any information about the minor children or the family with her boyfriend, who's an inmate at the Hutchinson Correctional Facility. And so those are the requests that I'm making today. To give you a little bit of history in this case, these parties were married July 12th, 2014. They have a son who is 7 and a daughter who is 4. Mom filed this action January 2nd, 2026. My client works for Koch Industries and makes approximately $90,000. Mom works and is the vice president of clinical services at St. Francis Ministries. She makes about almost $107,000. I do believe we can work child support out. However, the court makes a determination today regarding residency. There's no question the parties will have joint custody. It's just a matter of residency in this particular case. So at present, the party's eldest child attends elementary school in Rose Hill, and I should give you a little more information. My client left the residence and mom filed her temporary orders granting her to stay in the marital residence, which is fine. My client's not objecting to that. Then in this situation, she gave my client more limited parenting time and awarded herself primary residency. My client.
The hearing opens with the attorneys explaining the central dispute. Both parents want joint custody, but they disagree over shared residency. The father is requesting more parenting time, while the mother currently has primary residency under the temporary order. The judge immediately establishes the basic situation involving the two children, their schools, daycare, and the parents' living arrangements. This works well as the intro clip because it quickly establishes the custody battle and creates curiosity about which parent the judge will ultimately favor.
Is living with his parents, and he is living with them he is living with them in Augusta. So at present, their son attends elementary school in Rose Hill. The youngest child attends daycare, and she'll be out of daycare in June, and both children will likely go to camps this summer.
Okay, Ms. Goheen, where is the daycare for the 4-year-old?
It is in Rose Hill.
Okay, go ahead.
And historically, my client would pick up the party's youngest child and take her to daycare and then pick her up on his way home from work. And so obviously now we're in a situation where this divorce has changed things. My client is going to be living with his parents for quite some time until we get this divorce resolved. So what he's requesting is that mom have parenting time with the minor children every Wednesday morning at 8 until Friday at 8. Dad would have parenting time with the minor children every Monday morning at 8 until Wednesday at 8, and they would have alternating parenting time. And this is one of those good cases in terms of these parties do communicate well, and at least I hope that they're both focused on the best interest of the child, and I believe they are. My understanding from mom's position is in this case is that her concern is my client would need assistance to drop off their eldest child at school and pick up the eldest child at school. There's no concern. He will continue to do what he's done with the youngest child. So that's
he personally would?
He would pick up the youngest child and drop her off. He will continue to do that.
Okay, and the older one?
The older one goes to school a little later. So he would have assistance from his mom or dad. They're both retired in this particular case. Essentially what you're talking about is the children wake up at about 6. So my client also is in the position where he said, if I need to, I can drop off the eldest child at mom's house, and I'll continue to drop off our youngest child at daycare. I'll do whatever works for mom. If she's so opposed to grandparents dropping off at school in the morning, then I will drop the child off to mom in the morning. Then the only thing that would be grandparents would pick up after school. And if she wanted him to, I'm sure he would pick the children up, or the eldest child, from her at her house if she really insisted upon having the child at her house. These are grandparents these children are very, very close to. Luckily, these parties have good support systems. And so these aren't people that are unusual. They regularly use his parents to babysit. And so that's not a problem in this case. But we're willing to work with mom on whatever works the best. This doesn't change anything with the youngest child, who he was picking up and dropping off before. It's just the eldest child that we're looking at in this case. I'm not looking at a situation where I have to defend my client as a parent, because there's been no allegation that he's inappropriate as a parent. He is a great parent by all accounts at this particular time. This is also a good situation for shared residency because these parties can communicate. So the only thing that's at issue here, based on what mom has filed, is simply the pickup or the eldest minor child going to school and coming home from school. That's it. And so my client is requesting shared residency. The other issue is a restraining order for mom. She began a relationship with an inmate at the Hutch Correctional Facility, and both parties worked there previously. She was a mental health therapist there. My client was an officer. My understanding is mom has shared intimate details with this inmate about the family, including pictures of the minor children in this case. This is an individual who was convicted for ag kidnapping, ag battery, bodily harm with a weapon, ag battery, intentional great bodily harm, criminal threat, ag robbery without authority to enter with intent to commit a felony, theft, or sexually motivated crime. I looked at his disciplinary reports. They are extensive, and there were recent ones as of February of 2026, including dangerous contraband, including with weapons, threatening or intimidating others, incitement to riot, battery, lewd acts, and theft. Even more concerning than that, it appears that this gentleman's father served time in prison for rape, sexual intercourse with a child less than 14 years of age, amongst a variety of other crimes. So obviously my client has extensive concerns that mom is sharing pictures of their minor children and information about their family. I noted in her response that she tells this individual general information that she's going to practice for one of their children, and that she has shared pictures that are available on the internet. Obviously, my client is very concerned about this relationship. He knows he can't prevent it. I mean, that's mom's choice. I don't know if we will be asking for a mental health evaluation in the future, but certainly our concern is right now the best interest of the children, and quite frankly, my client, but lesser so, if she is providing information about their family to this individual. I'm concerned, based on her response, that she doesn't seem...
This is one of the most intense portions of the hearing. The father's attorney raises serious concerns about the mother's relationship with an incarcerated inmate and alleges that she has shared private family information and pictures of the children with him. The attorney then details the inmate's criminal history and disciplinary record, making the issue significantly more serious. The argument shifts from a normal custody disagreement into a question about the children's safety and the mother's judgment. This segment provides strong suspense and emotional weight.
Like, this is a problem, and her ability to consider the best interests of the children with respect to this relationship. So my understanding is mom has agreed to a restraining order preventing her from providing information or pictures or anything about the children, I would ask that that include my client, because I don't know what this individual is capable of. I don't know when this relationship began. She says in late 2025, and I'm assuming she met him when she was working there in 2019. I don't know what is going on with mom at this particular point, that this is a relationship she wants to pursue, but certainly I think she needs to realize the impact this relationship can have on the best interests of these children. My understanding is that Mr. Lemons, this individual, does not get out of the correctional facility until 2036, but obviously those dates can change. I'm going to guess it's not based on good behavior, judging from his actions for disciplinary reports on him. But my client is certainly concerned about that. And he does have a little bit of concern about her ability to look at the best interest of the child when this is the relationship that she's choosing to pursue. But at the same time, he understands he can't control that. So that's our position today, Your Honor.
Very well. Thank you, Ms. Goheen. Ms. Sewer, what would your client's response be?
Yes, Your Honor. The proposed child support worksheet that Jennifer Goheen filed did not include the daycare expense, but I do acknowledge that I had her client's income a little bit wrong, so I did file a proposed worksheet which included the correct income with the court last week, and I do agree with her that I think we can work that out, assuming we get some direction on if we use a shared residency formula or not. With regards to the current court order, the order grants dad every other weekend and Tuesday evenings. The youngest child goes to Primrose, which is in Wichita, for daycare 3 days a week, Monday, Wednesday, Friday. The maternal grandma watches the child Thursday, and the paternal grandma watches the child on Tuesday. Since the filing of this action, the paternal grandmother has picked up the youngest one, Brooklyn, in the morning, which she's always done, and then picks up Baylor after school, and then dad meets up after work and then brings them home at 7:30. He's also been attending the children's sports events on other nights, so he gets to support them and see them on those events as well, and we're glad that he's doing that. So Monday, for example, Baylor has baseball practice. Brooklyn attends, and dad and my client have both been attending since the separation. Wednesday's track is starting. So there are other times that he is able to see the children in addition to the every other weekend and the Tuesday night. We filed granting my client primary residency because she works from home, and she has been the primary caregiver of the children throughout the marriage. Historically, when the kids have been sick, she's kept them home, she's picked them up from school, she has managed to work, and she works from home, so that gives her the capability of doing some of those things. She's done the majority of the doctor's appointments alone. She's one that gets the medicine. Even post-filing, there's been a couple of illnesses, and dad did offer his mom to help on one occasion, but he himself hasn't offered or taken off time to help in those instances. She's been the one during the marriage to historically get the children ready for the day, with very rare exception. She did the majority of the bedtime and bath time routines by her estimate 90% of the time during the marriage. She's the one who regularly attended school functions, planned birthday parties, things of that nature. So we believe that the de facto arrangement is kind of reflected with the order that we filed with the court. In addition, the kids are well adjusted to their home in Rose Hill, where she's currently living with them. The neighborhood kids are over frequently. The kids have close relationships with their neighbors and other kids that they go to school with. Dad's parents live in the country, and so there's not a lot of neighbors, and we understand he's living there for now, and that's a good location for now, but we don't know where he's going to end up in the future. We don't know for 100% where my client will end up in the future. I know she's got some desires to keep the marital house, but that's still to be determined. I do acknowledge that prior to separation, dad did deliver the youngest to daycare on his way to work on those 3 days a week. My client would get the oldest.
The mother's attorney responds by explaining why she should retain primary residency. She is described as the parent who works from home, handles illnesses, medical appointments, school responsibilities, bedtime routines, and most day-to-day childcare. The attorney argues that the children are already comfortable in their current Rose Hill home and that changing the schedule could create unnecessary disruption. At the same time, the father's involvement in sports and childcare is acknowledged. This gives the audience the other side of the custody battle before the judge makes his decision.
Child ready, and he'd ride the bus from my client's house to school. Post-separation, my client has been able to deliver the youngest to daycare and get the older child on the bus because her schedule has more flexibility and allows her to do both, while dad's doesn't. He's not available to take both to school or daycare. And my client is a little bit unsure with having his family members help. It's a pretty big burden, and we don't know if it's feasible long-term when he's not living in their home anymore. His motion notes his parents will help transport to school, but we're not sure how the oldest would get home, as the bus doesn't go to his parents' house. My client's schedule with working from home allows her the flexibility. In addition, the oldest son, Baylor, has, about 8 weeks of school left, and he does have a history of struggling with changes and transitions. He's responded really well to the current schedule. My client let me know that his primary teacher will be gone for a full week in early April, and he's historically struggled with subs. So they've already put a plan in place with school to help with that transition that's going to be happening. And she's just concerned with another transition and then maybe doing domestic conciliation or the court making a different parenting plan in the future. And then there being another transition with a child that historically struggles more than the average child with transitions. The youngest child's going to be transitioning out of daycare and I'm assuming attending Rose Hill or some school for the first time for pre-K coming up next school year. Dad's parenting plan, I don't know if it contemplates that Wednesdays there's a late start for the older son, so that probably complicates the drop off and the exchanges a little bit more. Not sure that he knew that or contemplated that. So our request at this point in time is for the court to leave the parenting time as ordered. The alternate weekends and the Tuesday is working very well. There's the option for additional time as agreed upon. There's certainly the option to go to activities that don't fall on his days as he's been doing. And I think this would be an appropriate case for domestic conciliation. Have the domestic conciliator work out and look at the logistics, the work schedules, transportation, activities, where dad might live, where mom might live, and come up with a detailed plan that's going to work. Collaborative Success has a great amount of success with mediating agreements. And they're also really good at detail and logistics, which I think would help these people. So that is what we're asking the court to do. I did file a response with regards to my clients having a relationship with someone that is incarcerated. My client's position is that that in no way hinders her ability to parent effectively and lovingly to these kids. We agreed in our response to not take the children to the correctional facility. We agreed that she wouldn't discuss any inmates with the children. Historically, the children haven't been involved with this person. They're not aware of any correspondence or any friendship that she has. The children have never visited the facility. She indicates to me that she doesn't share information with the children. She doesn't provide specifics about the children. She might very in general be like, I got to get off the phone. I'm going to basketball practice, but she doesn't say it's at the Y or it's at X, Y, or Z school or any specifics. So we are fine with the court entering a restraining order, whatever order that the court feels is appropriate. We're not denying or saying that this would be a good person to introduce the kids to or start having correspondence with. That's never been her position. I don't care if you include Mr. Benaway in that she won't talk about him either. I don't believe that she ever has. If I had known that he had that concern, I would have stuck that into my response as well. But we do think that kind of restraining order isn't necessary because it hasn't been something that she has done or is wanting to do. But certainly we have no problem with that being entered as I indicated in my response. And I would say that, whatever order you make or whatever additional orders should stay in place long-term, beyond this temporary order can also be something that's addressed in domestic conciliation. So that is what we are asking the court to do, leave the parenting plan in place and order domestic conciliation to develop a long-term plan.
There are a couple of questions. Was Brian Benaway consulted regarding the terms of the original parenting plan and the temporary order?
No,
Was Ms. Goheen consulted, and did she have input into the terms of the original temporary order?
she was not retained at that point in time, so no.
I suspected as much, counsel.
Yeah.
Counsel, a temporary order is a stopgap measure. It's only meant to keep things steady until the matter can come to court. The court's had an opportunity to hear from both sides in this case, and Mr. Benaway has a very reasonable plan that he submitted to the court, which essentially would keep him equally involved with not only equal rights, but equal responsibility for these kids, despite some other logistical problems that the separation has caused. After all, the court takes into account, Ms. Sewer, that it's your client that filed the declaration of war in this case, a divorce petition, which basically says we're going to end our marriage and things are going to change. Realistically, they're going to change for the children as well. But the court at this juncture wants to see both parents equally involved and with equal responsibilities. This court will adopt the father's temporary parenting plan in this case as a shared residential custody arrangement. I do understand that there's going to be some changes in the daily routines of the children, different ways that they're transported from point A to point B. However, Mr. Benaway appears to have the resources in place to be able to cover his end of things. And obviously the mother is covering her end of things as well. And this court has no issue with grandparents doing transports. In fact, I can't think of any people that have a bigger stake in keeping things normal for these children than grandparents do.
This is the main payoff of the entire video. The judge questions whether the original temporary order was created after both sides had a chance to participate, then explains that the temporary order was only meant to keep things stable until the court could hear both sides. The judge states that the father has presented a reasonable plan and then delivers the key ruling. The father's temporary parenting plan will be adopted as a shared residential custody arrangement. The judge also confirms that grandparents can help with transportation. This is the strongest segment for the climax.
Except for the parents themselves. So obviously the court encourages their involvement at this point. Mr. Benaway, just some direction that the court would like to give here. If you're going to live in the Augusta area and you have a child that's in Rose Hill, this court will expect that there's not going to be tardies and there's not going to be unexcused absences caused by some logistical distance problem that you have on your end. In other words, the court's just asking you to make it work.
Yes, sir.
Further, as far as long-term concerns are concerned, you should at least think that if the children are going to be in Rose Hill schools, and I do understand that you've already got one in the Rose Hill school system, you need to live closer rather than further away as far as a long-term residence is concerned. I'm not going to tell you where to live, but shared custody arrangements work best when the parents live in close proximity.
Yes, sir.
Augusta is close enough at this juncture. Long term, the court wonders if that's a truly workable situation for the kids in the long term. Further, this court will enter an order that the mother in this case is not to share any pictures, video or audio recordings, or any other information regarding her children with any prison inmate, nor any information regarding Brian Benaway. Further, she's not to discuss any inmate business with the children under any circumstances. This court does have a concern about this relationship, if you will, if that's truly consistent with the best interest of the children involved. But at this point, it would appear that the mother's doing what she can to keep that separate. And the court's orders are meant to be a clear court directive that those things be kept separate. Obviously, the child support worksheet in this case, once tweaked as far as all of the numbers for input purposes, will be a shared custody worksheet, quite obviously. Ms. Goheen, you're going to have the responsibility of drafting this amended parenting plan order. I don't know who's going to be taking the responsibility for the child support worksheet. Ms. Goheen, will you be doing that as well?
Yes, I can do that.
Okay, and include the new child support order in your journal entry, which stems from today. As far as the effective date for the new arrangement, I think who would have the children starting Wednesday morning? Separate periods, but not which one you're intending for your client.
Here, I think I had him having the kids Monday until Wednesday at 8.
All right.
Yeah.
Then his time will start next week.
That's perfect, Judge.
We'll go with that plan. And then whose weekend would it be this weekend?
Brian?
That would normally be my weekend this weekend.
Okay.
All right.
It should be his weekend.
Okay. So his parenting time will then start at the beginning of weekend time, which I think is Friday at 8. And he'll go into his shared custody parenting time period early next week. Again, this is a temporary order to see if it works. It very well may be the basis for a long-term order, and sometimes it is, and sometimes it isn't. Your thoughts regarding domestic conciliation, Ms. Goheen?
I am fine with domestic conciliation if mom wants to pursue that after today's hearing. And I'll work with Ms. Sir if mom wants to tweak this parenting plan at all in terms of time. We do want to work with mom and Ms. Sir on that. But if she wants to pursue domestic conciliation, Judge, that's fine. I would object to using the facility that Ms. Sir had suggested, but I think that Ms. Sir and I can come up with an agreeable individual to do domestic conciliation.
Do you agree with that statement, Ms. Sir?
I would think that we would be able to agree to someone.
Okay, I have had to resolve disputes between attorneys before regarding the choice of a domestic conciliator, and I would rather not. Though I think there are a number in the Wichita metro area which this court would be comfortable with. So I'm sure whatever choice you make, counsel, this court will be perfectly fine with. The court will order the parties to participate in good faith in domestic conciliation with the idea of we're just working out a long-term parenting plan that's good for your kids and in their best interests. Finally, I did want to make a comment. I guess it really applies to both parties, but perhaps more to Mr. Benaway. There are times you may need to use the mother as a resource that's technically not her time. She is an excellent resource for your kids, maybe the best resource. If there's some reason why it doesn't work for your side of the family to be able to take care of something, perhaps the mother should be kept in mind as the resource that you go to next, and not try to exclude her because somehow you see that as she's getting an advantage in the case by having slightly more time than you. Ultimately, then, I think that really facilitates the best interests of your kids, especially kids that are 7 and 4. So I ask the parties to use each other as a resource when you need to.
Yes, sir. Thank you.
All right. I'm looking at my notes here, Ms. Goheen. Was there any other ruling that you were seeking from the court at this juncture?
No, Your Honor.
All right, Ms. Seward, is there anything today which you need clarification on?
I do not believe so.
It was stated at the beginning of this hearing that the parents communicate well and generally work together well. I hope that that continues, and I give you both credit for any cooperation that you do as parents, that when you work together for the best interests of your kids deserve that kind of cooperation. So I would just say keep it up. All right. If there's nothing further at this time, then the Benaway matter will currently be in recess, and this meeting may be ended for all at this time.
Thank you, Judge.
The judge then imposes specific restrictions on the mother, ordering that she cannot share pictures, videos, audio, or other information about the children with prison inmates or provide information about Brian Benaway. The judge also prohibits discussing inmate-related matters with the children. After that, the court works out when the new shared custody arrangement will begin, ultimately confirming that the father's parenting time will start with his upcoming weekend and continue into the new schedule. The judge emphasizes that the arrangement is temporary and will be evaluated to see whether it works.